Well, for many Indian parents, taking a child to the US consulate, it has always been stressful. Documents, photos, appointments, waiting, and when the applicant is a baby, parents, they naturally assume surely the baby does not need to come inside, right? But hold on for a second. According to TimesXP's report, US consular officers in India, they have clarified that minor applicants must physically appear for their visa interview, including very young children, maybe infants. So that means the parents, they cannot simply show up with a baby's document and say, hey, here is my baby's passport. Please process their visa. The child must be present. And yes, this applies across categories described in the report, including dependent visas and visitor visas. Now, can you imagine the logistics here? A family traveling from another city, an infant, a stroller maybe, feeding requirements, long queues, security check, multiple documents, and then a consular interview. For parents, this is not a small administrative change at all. It can affect travel plans, budgets, and yes, there is another important detail here, the child's documents that needs to match. Passport, birth certificate, DS-160, parents' visa information, photographs, relationship document, and even small inconsistency that can create a big delays for you. In the meantime, our report, well, it also highlights specific photo requirements for infants and reminds parents that a guardian, they must properly complete the relevant application process. But there is something important to remember here. This is not about the children who are being interrogated. No, a baby is not going to stand at the window and answer the questions. Well, the consular officers is verifying identity and directing questions to the accompanying parent or guardian here. So, if you are traveling with a child for a US visa interview, the bigger message, it is very simple now. Do not assume that age means automatic exemptions here. Check the latest immigration instruction before traveling, because let's be honest here, visa procedures can change, and the rules that applies to the child 2 years ago, it may not be the rules that are applied today. Well, for many green card applicants, advance payroll, it has been an important travel document. You have a pending adjustment of status application. You need to travel outside the United States. You receive advance payroll and you believe that you can travel and return while your green card application, well, that continues. But ladies and gentlemen, according to TimesXP's report, with a lot of research by the way, a new Board of Immigration Appeals decision, well, it has dramatically changed the legal landscape altogether. The decision, described as the matter of Del Carmen, Lara, reportedly overturned the protection that had expired under an earlier 2012 decision known as matter of Arabelli and Yarabelli. You know why that matters? It matters because the legal definition of leaving the US, that could become extremely important when somebody has previously accumulated unlawful presence. In fact, the report also explains that more than 180 days of unlawful presence, it can trigger a 3-year ban after departure, while 1 year or maybe more than that, it can potentially trigger a 10-year bar. Now, if we talk about the older interpretation, some people using advance payroll, they were protected from triggering those particular bars simply by traveling. Well, the new ruling described in the report, it changes that understanding now. And this creates a very serious warning here. An approved advance payroll document that does not automatically ease your immigration history at all. That's a misconception now. Ladies and gentlemen, if somebody has a very complicated history of status gaps, overstays, or unlawful presence, international travel, it can become a much bigger legal question now. And that is why this is not a story where one simple piece of advice applies to everyone. Two people can both hold advance payroll. One may have a clean immigration history, another may have a long period of unlawful presence here. Well, their risk can be completely different. Adding more than the report, it also says the ruling applies prospectively, meaning that previous travel completed before the specified date, it may be treated differently. But for people planning travel now, message is very clear. Do not assume that holding a travel document that automatically means travel that is risk-free now. Well, immigration law is extremely fact-specific. Dates matter, status matters, previous applications matter, and sometimes one trip can affect an application that has taken years to build. So, before traveling internationally, somebody with a pending immigration case and a very complicated status history, they should get case-specific legal advice. You know why? Because this is not a situation where a social media post or a 5-minute online video can replace professional legal review.